All right, good morning and good afternoon, everyone. My name is Gabriella Barbosa. I am co-chair of the Los Angeles Lawyer Chapter of the American Constitution Society. Welcome to each of you joining us today for the first panel of a series of discussions we are hosting focused on racial justice and the law. I'd like to start by providing some context about this series. The ACS Los Angeles Lawyer Chapter stands in solidarity with those demanding justice and systemic change in order to overcome the continued violence against and devaluing of Black and Brown lives, rooted in a painful history of oppressive laws and policies. Racism has long been a central tool for those who wish to hold on to power. It has infected our systems and institutions, creating and sustaining inequities across public education, housing, health, child welfare, the environment, the criminal legal system, and more. Those inequities have been obvious for decades to anyone who wished to open their eyes, and our eyes are open. We see the ongoing legacy of oppression, and we see the ways those same forces continue to manifest themselves. And that is what brings us here today, on Constitution Day, 233 years after our Constitution was signed. As lawyers, we hold a unique obligation to fight for our democracy and the values underlying our Constitution to protect the rights, humanity, and dignity of all people. ACS Los Angeles has committed to challenging and disrupting systems of oppression by launching a series of discussions focused on unpacking and understanding systemic racism within the context of various areas of the law, as well as sharing recommendations in law and policy that you all can uplift in the movement for equity and justice. I'd like to express our deep gratitude to our moderator and panelists, Jody Armour, Tiffiny, Blacknell, and Fred Smith, as well as our co-sponsors, the Mexican American Bar Association and the ACS lawyer chapters of the California Bay Area, San Diego, Chicago, Washington, D.C., and Austin. Also, a special thank you to Princess and Molly at ACS National. You all have made this series possible. And thank you to our attendees for being here with us today. We encourage you to participate through the Q&A function, and we will be reserving 15 minutes at the end of the conversation to answer your questions. Also, please look out for an announcement about the next panel of this series taking place during the week of October 12th that will focus on voting. Now I'd like to hand it over to my colleague, Olivia Hudnut, who is co-vice chair of our chapter in Los Angeles. Olivia?
Hello. I am going to introduce our moderator and esteemed panelists today, starting with our moderator, Professor Armour. He is a professor at USC Gould School of Law and the Roy P. Crocker Professor of Law. He's also an author and a playwright. He's recently published a book, his award-winning book, Negrophobia and Reasonable and Various Communities and Culture. And he's also recently published N*GGA Theory, Race, Language, Unequal Justice, and the Law, which was released just this past August. He's a widely published scholar and popular lecturer, and he is also a Soros Justice Senior Fellow of the Open Society Institute Center on Crime, Communities, and Culture. He earned his undergraduate degree in sociology at Harvard and his JD with honors at Bolt Hall Law School at UC Berkeley. Prior to joining USC, he was an associate at Morrison and Foerster, Kirkpatrick, and Lockhart, and taught at UC Berkeley's Bolt Hall, Indiana University, and University of Pittsburgh. He currently teaches a diverse array of subjects at USC, including criminal law, torts, and an excellent seminar on stereotypes, prejudice, and the rule of law. So join me in welcoming our esteemed moderator, Professor Armour. And we also have with us a constitutional law professor, Professor Fred Smith Jr. from Emory University School of Law. He is a scholar in federal judiciary, constitutional law, and local government professor. In 2019, he was also named the law school's Outstanding Professor of the Year. So we are very lucky to have him here. He's also been a clerk in the Middle District of Alabama, United States Court of Appeal for the Second Circuit, and for Justice Sonia Sotomayor of the United States Supreme Court. He also worked at Bondurant, Mixon, and Elmore LLP in Atlanta prior to joining the faculty at Emory School of Law. His research focuses on accountability, federal jurisdiction, and state sovereignty, and his work has appeared in numerous law reviews. He also volunteers in numerous capacities in promoting equality, equity, and social justice. He serves on the board of Invest Atlanta, which serves the Economic Community Development Authority of the City of Atlanta. He also serves on the Atlanta Mayoral LGBTQ Advisory Board, the National Board of Lambda Legal, and National Board of Civil Rights Corps, and the LGBT Advisory Board of Historic Atlanta. Professor Smith was a founding member of BeltLine Rail Now, which advocates for transit on critical corridors around the city of Atlanta. He also served as the inaugural advisory board member of the Harvard Debate Council Diversity Project, which annually trains Black Atlanta youth in critical thinking and public speaking. So his alma mater, his undergraduate alma mater, was Harvard College, and he went to Stanford for law school. And our next panelist is Tiffiny Blacknell. She is a Deputy Public Defender at the Los Angeles County Public Defender's Office. She graduated from USC Gould School of Law in 2002 and immediately began working at the Public Defender's Office here in Los Angeles. She has 17 years of experience as a Deputy Public Defender and has handled a variety of misdemeanor, juvenile, and complex felony cases, including a special circumstance murder. In 2018, she was honored for her outstanding advocacy at Kessler Award. And when she isn't busy handling her cases and taking care of her 3 children, she finds time for activism. She's very active in the Los Angeles County Public Defender's Office, and she is the past president of the Black Public Defenders Association, the co-chair and founder of the Women's Association, and a member of the Racial Justice Committee. She is also active in the community and is on the board of directors of a nonprofit organization which supports formerly incarcerated citizens in reintegrating into the community. So without further ado, we'll turn the conversation over to our moderator, Professor Armour.
Thanks a whole lot, Olivia, and it's really a pleasure to be here and having this conversation with 2 such distinguished interlocutors. Constitution Day. Wow, it's a propitious time for us to get together. And I'm thinking, when does constitutional law come up in my criminal law course or in my torts course? It's kind of all over the place, right? It's a constant. But one of the things I talk to my tort students about when we get to constitutional protections, that the intersection between torts and constitutional law, like defamation and other areas, invasion of privacy, et cetera, I tell them that constitutional protections are like coils that a body politic can use to tie itself to the mast, you know, at the urging of its higher angels, when it comes up with some principles that it wants to live by, be defined by, and adhere to, but it knows that a later, less principled self might tempt them to go in another direction. They come up, they protect, you know, these insights from the higher angels of their nature, if you will, by giving some interest constitutional protections, i.e. they're binding themselves to the mast like Ulysses, right? All my 3 boys had to go through, you know, that particular book, the Odyssey, and thinking about him tying himself to the mast. So when he heard the siren songs warbling from the shore, he wouldn't abandon his principles, dive in the water, and go toward those rocky shores. Now, that means that sometimes it's hard to live up to constitutional protections and demands. When those siren songs, you know, I call it siren justice. When siren justice starts warbling, a lot of us are tempted to hack off those coils that Ulysses has binding him to the mast and dive into the water in the name of siren justice, right? And we see that all over the place all the time. And you can even see it, you know, speaking of racial justice during COVID-19, Black communities bearing the disproportionate brunt of it yet again. And a lot of people are saying, well, it promotes the general welfare for us to be able to go out here and do our nails and go to Fridays, et cetera, And yeah, there may be some casualties, some deaths disproportionately in the Black community, but for the sake of promoting the general welfare, why not, right? That is, you know, that's tempting. I can see that. If you recognize, right, that the Black people whose lives you're sacrificing, though, have rights, right, that you have to respect and not just do a cost-benefit analysis on and throw their interest in with a whole lot of other interests and mix them up and see what promotes the greatest aggregate interest, but rather you say they have a damn right that we have to respect and defer to even when it's inconvenient. You know, even when it's damn inconvenient, we're not going to give in to Hunger Games logic, where we go around sacrificing individuals on the altar of the public good, right? So we would, if I think in this moment, if we were more mindful of a kind of rights-based approach and the rights of people not to be killed by a raging pandemic that is preventable, if we take a lot of the death is preventable if we take adequate precautions, but do we make that judgment on a cost-benefit basis like the law and econ people want us to and the instrumentalists want us to, or do we do it on a rights kind of basis like the non-instrumentalists want us to do, like, you know, like the people that I support the position of in my latest work do. So, you know, that's kind of how I'm entering as I'm thinking about this on Constitutional Day. We're going to talk about some fundamental rights, I hope, some fundamental interests that don't have to genuflect to the greater good, you know, whenever there is a issue about, you know, how much we're going to sacrifice some of our fellow citizens for the sake of other interests. So I'm going down that road, and I was asked to say a few words about my recent book in this intro. So I'm just going to say this about it. The N-word is the most blood-stained epithet in the English language. It has deep etymological roots that run into avowedly virulent racism, and I don't discount that in any way. And that's part of the reason I use that N-word in the title, because I heard people like Chris Rock and Bill Cosby, a lot of other people using that N-word about other Black people, all right, in a negative way that I want to attack in this book. And we can get into that more as well. But I also know that the word can be used as a term of endearment and a way of standing in solidarity with people who are otherized, demonized, and niggerized by society, right? So I use it in that sense too. And the most niggerized people in American society are violent Black criminals and homeless people. I'd say those two populations, right? And homeless population, by the way, you go down here at Skid Row, the fiercest expression of structural violence in America, highest homelessness encampment in America, 75% of the faces are Black. Right, so I want us to really think about what the implications of those realities are, psychological implications. I talk about that in the book a lot, you know, political, philosophical, moral, all of that, and we'll have those conversations today. So that's all I'll say about that, and we'll talk about it more as we go along. But I really want to hear from my fellow panelists here. I'm moderating, but I'm going to step out of the way now and first start with the first question on my on the key questions that were we were developed ahead of time by some terrific people at ACS. I think these cut right to the quick. Thank you very much, by the way. And oh yeah, thank you ACS. You know, this is much needed. We have to, the people marching in the streets for the last, for 6 weeks straight and who knows how much longer, they were out there saying we need to rattle the foundations of this nation, right? And this is foundational work that ACS is doing, right? And that's what we're going to talk and think about now. So much love. Thank you, ACS. Let me start with the constitutional question. We have a constitutional scholar par excellence, terrific articles. The ones when I knew I was coming on, I jumped on, of course, and did my due diligence. And whoa, you can write, brother, and you're sharp. So I'd like to hear, and Tiffany and I go back. She knows, I think, the world of her. She walks on water. Let me start with you though, Professor Smith. How do our Constitution and judicial precedent treat systemic racism?
Thank you. Thank you for the question, and thank you to ACS Los Angeles for inviting me. One of the kind of unusual things about this moment we're in with Zoom and virtual is that we can be in lots of places on the same day. So it's a pleasure to be able to join you this way. So how does the Constitution and judicial precedent treat systemic racism? I suppose there's lots of ways to come at that question. One would be to start with the text itself, unamended from 1787, and to ask, how does that document treat systemic racism? How does the text? And I think we're all familiar with things like the 3/5 clause. I think we're all almost certainly familiar with the fugitive slave clause, which may be in some respects more odious than the 3/5 clause, right? In the sense that it enshrined into our constitutional document that if someone were to escape, that they were to be able to be kidnapped and return to their so-called masters, right? And then there's another part of the Constitution in terms of the text that gets very little attention, and it's the part of the Constitution with respect to the amendment process. So it turns out that in the Constitution, it's specified that there are two parts of the Constitution that are unamendable. One part of the Constitution that was deemed to be unamendable is the idea that every state gets gets an equal number. It doesn't say two, but it gets an equal number of senators, right? So the Constitution could be amended to allow for 3 senators, for 1 senator, but every state has equal suffrage. Certainly one could make a case structurally about the racial implications of that alone, but the other part that was unamendable was with respect to the Middle Passage and the slave trade. That is, the Constitution specifies that it was unamended, that it was unamendable that the slave trade would be able to continue, the importation of slaves. It doesn't use the word slaves, it uses the word persons, but the importation of slaves up until 1808. And that was unamendable. To move that to any earlier date would have been, could not happen even by amendment, right? And so in the original document itself, right, there are these, built into it is this pact with slavery, which is an inevitably racial subject, right? In all the obvious ways, but sometimes when I read cases, even I know it's there, but I'm still sort of struck. There's the Virginia case from the early 1800s where a Native American petitioned for his freedom, and the court wrestled with, well, who can be presumed to be a slave? What the court says is, well, you can't just look to skin complexion. What you're trying to figure out is whether or not they are of the African race, and over time, the complexions are going to get lighter in light of, well, they don't say in light of interracial the rape of slaves, but they say over time that might change, but what hangs on longer is the texture of the hair and the size of the nose, and anyway, it goes into great detail in terms of how to determine whether or not someone should be presumed to be a slave in judicial language and in judicial opinions. So that's the original document, right? But how else does this document deal with structural racism? Well, there's the Reconstruction Amendments, the 13th, the 14th, the 15th Amendments, right? The 13th Amendment eradicating the institution of slavery, the 14th Amendment guaranteeing equal protection under the law and due process and giving Congress the ability to enforce both. The 15th Amendment, which it said that one could not be denied the right to vote on account of color. And in these, right, we might think that even if the original document was even perhaps illegitimate, as Thurgood Marshall once said, that maybe this amendment process was helpful in sort of bringing the Constitution forward. All that said, it wasn't until the mid-1960s with sort of the second Reconstruction, which didn't involve constitutional amendment, but it did involve Congress using its congressional powers under those Reconstructions. Prior to the Voting Rights Act, less than 7% of eligible Black voters were registered to vote in the state of Mississippi, because if they attempted to, they would have been murdered. Right, so the physical violence combined with a long history of structural violence made that impossible. It wasn't the same. It wasn't identical everywhere. Here in Atlanta, Black folks began to vote in meaningful numbers in the 1940s, but even that is a long way after the Reconstruction Amendments of the 1860s. So those are some of the kind of general historical ways that the Constitution treats structural racism. I tend to write about the architecture of enforcement. That is to say that even when we recognize rights, even when judicial precedent recognizes rights, that rights without any way of enforcing those rights are really no rights at all. And so I write about, I'm a federal courts professor, and I write about doctrines like standing and abstention and qualified immunity and sovereign immunity, which are phrases, especially terms like abstention, that tend to cause people's eyes to glaze over. But they're important to the architecture of the enforcement of rights, including the rights of poor folks and Black folks. And so my article, Abstention in the Time of Ferguson, from 2018 in the Harvard Law Review, is an attempt really to kind of make sure that we have an actual architecture that allows people to be able to enforce their rights, including the folks who are the most marginalized.
Great, thank you. And Tiffiny, let's make the rubber meet the road now, in a sense, because I think Professor Smith gave us a beautiful segue when he talked about enforcement. You would have to think about the rubber meeting the road at the level of lawyering. How do we get at racism? And you are an outstanding lawyer. So can you help us understand our second question? How can lawyers challenge systemic racism?
You know, what's interesting about this moment is that, public defenders have been sort of doing this work in courtrooms across the country since forever, in terms of drawing attention to the harms that the carceral system causes within the Black community. When we protested downtown, our public defenders wrote signs that said, "Black lives have always mattered to public defenders." And we're sort of the foot soldiers in this anti-racist war in terms of the criminal punishment system. But LA County, for example, where I practice, has the largest jail system on earth. It has the largest prosecutor's office on earth and the largest public defender's office on earth, with over 700 public defenders in Los Angeles County. That's an extraordinarily powerful group that has litigated these issues in criminal courts across the country, across the county, and has actually seen the way these ideas play themselves out and affect the lives of our clients. And so I am now the recruitment coordinator for the office, and I think of myself as a bit of a dragon in terms of drawing attention to the injustices of the system. I think that too many folk are polite and professional in their demeanor when they are witnessing human carnage on a daily basis. I think the system thrives off of people who are sort of okay or sort of have been desensitized to the harm that you witness when you see human beings in chains literally every day of your career. And so I think that lawyers who are in this work, in the work of criminal defense, in the work of public defense, need to unsettle the system because it's running too efficiently. And I think that the system is designed to be efficient, and it's designed to press on the backs of public defenders so that they submit and surrender their clients at the earliest stage possible. And so you find that 96% of cases are pleading guilty, and no one's actually challenging the system in a way that will hold it accountable. And so I think I call for lawyers and law students and to be more aggressive in their search for justice. And that begins at arraignment. That begins at challenging every bail schedule, challenging the bail system itself, litigating release. And I don't just mean a 30-second pitch in a busy downtown courtroom. I mean calling witnesses, presenting evidence, and holding the system to account. And that is just the first stage of things, right? At the point at which your client's body has been turned over to the government, you've already lost that first battle. But don't mail it in, right? You may know this bench officer for the last 5-10 years of your career. You may know their answer is already set in stone. You challenge them anyway. And you do so at the first stage from the preliminary hearings period. Even though we know a preliminary hearing oftentimes is a rubber stamp, challenge it anyway. You may know the judge you're in front of for your motion to suppress because of the illegal search and seizure believes every lie law enforcement ever put forth. Challenge them anyway. You might know that you may be afraid, right? I always say that fear has no place in public defense, but there are people who are afraid, and rightly so, that if they opt towards a jury trial, that judge will make you pay. If you dare lose that jury trial, that judge will make you pay. Try the case anyway, because without that force, and I think LA County Public Defender's Office has some of the finest public defenders or defense attorneys in the land. As a collective, we could put pressure on every crevice of this system and crush it because of our sheer size. The system is realizing now, because COVID has interrupted jury trials for six months, they have over 7,000 criminal trials ready to go when we open. That is extraordinarily powerful as an office, as a unit. We are a sleeping giant in this business, right? But you can't control the choices that other lawyers make. However, as an individual defender, you can call it as you see it. If you have a prosecutor, for example, who's excluding Black people off of juries, you call them out. Call it what it is, right? You don't let it pass because you want to be professional and polite and you don't want to make anyone uncomfortable. Or you are relying upon your relationships with the parties, the actors in the system. So, of course, you don't want to use the race word. No, I think that the new generation of lawyers, the ones that I interview every day, this week alone, I've interviewed 30 people to be interns in our office. This generation is knowledgeable in a way that we weren't. Because I interviewed people 10 years ago to be lawyers in our office, and I'm telling you, the folks that are entering the work today will call it out. You ask them, what are the three main drivers of mass incarceration? They say white supremacy, colonialism, and capitalism. Period, without hesitation. These folks know what it is. So I don't want them to be silenced when they enter the actual work of a public defender. I want to encourage people to burn it down, right? Of course, not like literally, but figuratively, because I think that the system is just running it's like a train down a track, and Black bodies are lined up and down the railroad, right? And so we need to call things out. We have a juror, for example. I've had jurors literally tell me that Black people are more likely to be violent. That is her honest, in a packed courtroom, right? You literally, these are the kind of things that happen in jury veneers, and you have to challenge the veneer. You're not a jury of my peers, right? So at every stage of this process, we need to litigate. You know, like John Lewis says, get in that good trouble. And I know it's not always easy to do, especially over the course of a career. But if public defenders and defense attorneys alike do not want to be complicit in mass incarceration by feeding your clients over to this system, which destroys them, then you need to interrupt it. And that takes a lot of energy, and that takes a lot of self-sacrifice. But I know that there are strong, hardworking public defenders every day in this country who do the work. and who are able to do that. And every now and again, the clouds open up and glory shines down and you free a body from a system. You save a community, you save a father, you save a son. And it's glorious, right? But we can't be so afraid of losing, afraid of offending the bench, afraid of offending prosecutors that we don't call things how they are. And I'll give you a quick example of that. With my own career, the week that Alton Sterling and Philando Castile were murdered by law enforcement, I had a motion set, a suppression motion, where my client, Latinx young man, walking down the street, literally on a summer day, eating an ice cream cone. And the police decided to pull him over for what they determined to be a consensual encounter. That consensual encounter amounted to him blocking a driveway, pulling into a driveway in front of my client, stopping his squad car and getting out and saying, "Come here." That was described as a consensual encounter. And even though my client testified that I told him I did not want to be searched, I do not consent to search, he searched him anyway in the Terry way, right? And I knew what the bench officer I was in front of would do. I knew he would say the officers had reasonable concern for their safety because of the high crime area. And I couldn't deal with that in that week. So I postponed that hearing for fear that I would literally unravel if I heard him say those words, that this young man eating an ice cream cone was somehow a risk to them. But that's what Terry looks like. But I filed that motion, I argued that motion, I argued the racist issue with that analysis, and I was denied. And I appealed it, and I was still denied. But the glory is in the fight, right? Even in defeat, you have held the system to account in some way. And the next time that officer sees me coming, he knows that I will never submit to that. I will never read that police report and not file that motion. But it's extraordinarily costly to defense attorneys to file those motions and hit those walls again and every single day of your career, because the bench is not abiding by the spirit of the Constitution, right? It's been abandoned long ago, where folk have literally in their decisions, in these motions, in these hearings, are telling you that the Constitution does not protect you. And what supports that analysis is that a belief that the police are right. You are a danger. You're just your black body, walking down the street, your brown body, eating an ice cream cone. No matter what you're doing, you are a danger. And no matter who you are, if you're in a black community, you're in a high crime community. And so because of that, the Constitution allows me to seize you, right? You know, there's a difference between being pulled over if you're a white person in certain neighborhoods and being asked for your license and registration and to be advised that you were pulled over because you're speeding. When you're black and brown and pulled over, are you on probation or parole, right? That is the common refrain. This tail light Wren has empowered them to use the tail light as an excuse, as a pretext to get into my space. And so they've used it. They've run away with it. You know, we have data, right, from the LA Times last year, from the ACLU. We have data on this, that they use those excuses to get into the space of black and brown folks to ultimately ask you the question, are you on probation or parole? Terry frisk you, Terry stop, right? And then you search the car because on probation or parole and looking for guns and drugs. That's it. It's an open secret that they don't care about the pretext on which they stopped you. So I think as lawyers, you cannot allow the realities of the system to disenfranchise you in such a way that you stop challenging it. That's my main rally cry, is that as lawyers in this system, we have to demand that they acknowledge the rights, both the human rights, civil rights, and constitutional rights of our clients. And if we start submitting, because it's unlikely we'll win, then we've let them win already.
Public Defender Blacknell, let me press you a little. Those are great points, outstanding. Let me press you a little with one of the dilemmas that may be confronting public defenders in that position. I'm thinking about one of the cases that the incumbent DA for LA County, Jackie Lacey, when she was first running in LA Weekly, they reported a story of how she presented an 18-year-old black boy who had taken a cell phone from an unoccupied car, the back seat of an unoccupied car. And as a 16-year-old, he had 2 prior purse snatching incidents. She got 25 to life for that cell phone. And when the judge, you know, in rear feet of judicial, I don't know what, compunction about the sentence, a little later tried to reduce it to, and here's the key point, reduce it to the 7 years she originally offered him, right? This was a trial penalty that he was suffering, right? The 7 years she originally, when the judge tried to knock it down to that, she objected and fought it. All right. So when you have a client facing a DA like that, and you know your client, and you know this DA is might be coming for 25 to life if you don't take this 7 years, which is obscene for that cell phone in its own right, but you're confronted with one obscenity versus an even grosser obscenity. Right? How do you, and while promoting the best interests of your client, really try to litigate aggressively and zealously?
And that's why I have a lot of sympathy for folks who, both lawyers and clients, who opt towards the plea, because they're not wrong, right? There is fire on the other side of that guilt. If that guilty verdict comes in, we know what will happen, right? But I think that's how they win. I think as a lawyer, you need to be able to analyze a case and advise your client properly about the avenues of success that you do have. And I don't want us to be overly pessimistic about the likelihood of success, because unless you've tried cases, you don't know what case you can win or lose. Unless you've been in the arena, things may look bleak on paper, but when they come out in trial, it's a whole different game. So unless young lawyers get their feet wet, get their hands dirty in the arena as young lawyers, when the stakes are not life, when the stakes are 6 months in jail, when the stakes are a year, when you can hone your skills and get to know your way around a courtroom so that when you reach those type of decisions, you make them wisely. But of course, there are no guarantees. I had a client who was offered 11 years for a manslaughter. I believe to this day he's not guilty, self-defense case. He turned it down with my advice, and he's serving a life sentence right now. It felt like a gunshot when I heard those words. So I appreciate the fear. It was devastating for him. And I remember going in the back with him just with my head in my hands, like, I'm so sorry. And he goes, "You're too hard on yourself. We were right. I shouldn't have taken that deal. And you did the best you could," right? We have those devastating moments, but no one said public defense was easy. But we need to, as a society, put pressure on the bench when they do that. Because if a bench officer is willing to accept a 7-year plea bargain before trial, if no new facts have arisen in that trial, why is it unfair to do it after trial? And you, like I said, you called them out on that. This DA who is now asking for a life sentence was willing to give this person 7 years. If it was fair a week ago, it's fair today. And these judges who do operate with the trial penalty need to be held to account and voted out. And the population needs to be more aware of who these people are and how they operate within their different courtrooms. Because we should not be punishing folks for using their constitutional rights.
Great. Fred, what are some of the constitutional issues that you see arising in the context of blame and punishment, right, in the criminal justice system? Are there some areas that you found especially, either intriguing, important, in your thinking about these issues from a constitutional law perspective?
Yeah. Well, first, I just want to say that those stories really hit me, the system is just so broken. And I know why we're calling it the criminal punishment system, because we don't want to call it the criminal justice system, but it begins before the criminal system, and the injustices of it begin well before punishment. As public defender Blacknell just made clear, right? From the moment that where someone stopped. Technically, under the Constitution, that's not a punishment. We're not in Eighth Amendment territory. We're in Fourth Amendment territory. Then they're taken off to jails, which technically isn't punishment. They don't have the protections of the Eighth Amendment in that particular context. They do have some protections by virtue of the Due Process Clause when someone's a pretrial detainee. But on any given day, there's 750,000 people or so who are in jail awaiting trial, right? And so I don't, the architecture of the system, and this is, I mean, everything that everyone is saying is consistent with that, but I just want to make it clear that it begins before punishment. In terms of specific doctrine, so I'm a Fed courts person, and I teach, the basic con law class. And so, I'm not an expert on criminal procedure as such. I don't teach criminal procedure. But as a public defender, Blacknell has noted, that's where a lot of the injustice happens, right? So the Wren case that she cited, which allows, again, for pretextual stops, that opens the door to a lot of these interactions. The same is true with respect to Terry, allowing people to frisk people, and I don't think that when Terry was decided, that it's fully appreciated what that looks like and what that means, how unevenly this is in fact applied, and what it means day after day for someone multiple times in the same year in the same neighborhood to experience being stopped, being asked questions that treat them as a suspect from the outset rather than as a citizen, to have their body frisked and searched. And Bernard Harcourt has written about ways in which some of these searches turn into exceptionally invasive searches. And what does that mean? I mean, what does that mean for a society? So Monica Bell has written about how this creates a sense of legal estrangement. That is a sense where people don't feel, it's not even second-class citizenship. They don't feel themselves to be a citizen at all. They feel that this project called government, that is entirely disconnected from their own lives. And so because we call ourselves a democratic republic, I think on this Constitution Day, we should ask ourselves, what does that mean? That's a real issue. That's a real crisis. And how do we work our ways out of that particular crisis? So in terms of some other constitutional doctrines, though, what I write about qualified immunity and abstention and sovereign immunity and lawsuits against local governments. I'm proud to write about those things, but I will say that I rather it not happen, right? Like I rather the person not experience the injustice that puts them in the position in which they are suing the city or are suing the officer. And so thinking about things like the Fourth Amendment is an important piece of this, and also thinking about ways in which we rely on the most violent arm of the local government, namely police, to handle so many different social, let's call them social problems, that cause police and the public to kind of, especially Black and poor folks and Black poor folks, to constantly be in interaction with the police. And so if you have these constant interactions that are themselves unjustified and don't make sense, and you're using the most violent arm of the state to do it, and you're doing so in a society that has more guns than people, the end result is obvious at this point, right? And so if we're going to prevent it, we have to think about, again, how do we reduce the number of these interactions by virtue of thinking differently about the things that we label crime, and thinking differently about who responds to them, and revisiting, if we can't revisit the Fourth Amendment, revisiting in state law various protections that are more protective, because states can be more protective than the federal government, even though they can't be less protective. And so thinking about how to go about that, especially in, I live in Georgia, but y'all are in California, right? So there's a little more, I love Georgia. However, the political space here is a little bit different. Our governor's Brian Kemp. And so this is a beautiful moment, though, for places like California, where I used to live. I used to teach at Berkeley. It's a place that's special and dear to me. Thinking about that, I think, is important too. Not just the federal Constitution, but how do we do more at this moment? There's a lot in your state constitution that's unhelpful, but this might be the moment to revisit it, right? I mean, you may be aware that in your state constitution, I know that y'all are aware, but the lawyers, y'all might or may not also be aware that your criminal, the amendments for criminal procedure are tied to what happens with respect to the United States Supreme Court. That was put into place in the late 1980s, and that was a very different environment in California than the current one. And so that this may be the time to kind of revisit those sorts of things. And I'm happy to talk about qualified immunity and the like too. But I like the focus here on the criminal system itself, rather than attempting to get justice after the fact, even though that is its own mess, no doubt.
Great. Yeah, minimizing contacts has been really the driving rationale of defund the police, right? As well as unbundle the police, or whatever term you need to use to not get too anxious about hearing. People didn't get anxious about defund healthcare, defund, schools, defund a whole lot of other. They knew what it meant then, but somehow now it means total abolition to everyone. But we've been talking a lot, and a lot of times we think about, when it comes to criminal justice matter, criminal procedure, but not as much about the substantive criminal law, where we make judgments about the subjective culpability and just deserts and levels of punishment and conditions of confinement, right? And that's where that story about Jackie Lacey, that's what shocks the conscience. Even if he did something, 25 to life for a cell phone and unoccupied car, but the Supreme Court says again and again, when it comes to the Eighth Amendment, proportionality analyses are very thin, right? When they let just about anything a legislature here in California, speaking of California, El Segundo, you had a guy walk out of a golf shop with a couple golf clubs and got consecutive 25-year sentences at the end of all of that for those golf clubs. And the Supreme Court said, yeah, that passes constitutional muster. No problem, Eighth Amendment problem there, right? So we talk a lot about the procedural protection, but where are the protections for the basic humanity of a defendant, the respect that you'll have for the person of that defendant, not to treat them as just so much toxic human waste to be dumped, warehoused, and forsaken by us, that which is without any constitutional intervention. Now, there are some, there's some hope, I've seen of constitutional intervention. I didn't think I would see it in my lifetime, but I saw it. First they stepped in and said, no, you cannot put to death those who have certain cognitive deficiencies. And you can't put to death people who were minors at the time of the crime. Whoa, those are made. What they're saying is you cannot reliably determine that they are the worst of the worst, that their subjective culpability makes them deserve the death penalty, right? So I didn't see those coming. I was so happy to see them coming, but I haven't seen them spreading much, giving Eighth Amendment protection outside the death penalty area to disproportionate punishment, right? But do you see any hope there on that substantive side of things? I know, you're running into it a lot, public defender Blacknell. Are judges still saying, well, my hands are tied, I have to give out these sentences? Are you finding that you can speak to judges in compassionate terms now that maybe they weren't as sensitive to a year or two or three ago about how draconian these punishments are? Do you see a movement among voters? The voters of California passed Proposition 47, knocking all these felonies down to misdemeanors. We see a lot of movement among voters that the politicians aren't catching up with yet. But what are you seeing in your practice?
Much of the same. I think culture is hard to change. It's hard to change a shift in ways of thinking. They've been thinking this way for at least my entire career. And so I don't know if I mean, I think that the laws have empowered the lawyers to actually go in there and make these arguments. I think that the election cycle itself has encouraged folks to be more reasonable, because I think the people who are up for election are actually thinking about the possibility of the voters turning against them. The old sort of tough on crime, fear mongering that worked in past generations has sort of turned a corner, and people are starting to see that mass incarceration isn't really the answer to our problems with violence. So I think that the bench will be the last ones to know, right? But my arguments haven't changed, right? I have always been, this is a human being, in case anyone forgot, right? I've always made those arguments to the point where a judge once saw me coming and said, I know, Ms. Blacknell, none of your clients belong in prison, you know, right? Because I never submit to that. In fact, when on the Franklin issue with youthful offenders, the law has acknowledged that you shouldn't send youthful offenders to prison for life without parole or the equivalent. So I had a young man charged and convicted of first-degree murder, where a murder charge in California is 25 to life, right? You add a gun to that murder, they add another 25 to life, a total of 50 to life. But if you have a person who shoots in a crowd, the DAs just sort of make up however many attempted murders they want to based on the number of bullets discharged and add 7 counts of attempted murder to John Doe's without anyone coming to court and saying they were injured, it nearly struck me, I saw the bullets coming, nothing. Just 7 counts of attempted murder on John Doe's plus the gun allegation, which makes 40 to life consecutive. And you have DAs literally walking into courtroom briefs asking for 250 years to life, as if the 50 to life wasn't enough. And so when this happened with me, I took it upon myself to just climb up on a soapbox and announce to the entire court that you all have been caging humans for a generation when you know their brains were not developed. And the legislator, the people of the state of California, have spoken. We are done with that. So you may give him 250 years to life if you want to, but just know that this man will receive a parole date in 25 years, no matter what you do. And that is the law. No matter what they sentence him to, under 25, he has to have a day to be heard on parole, at the parole court. And in this situation, the judge, despite the law, sentenced him to 90 years to life. Well, thank you, Your Honor, for your humanity, right? And it's literally a fiction what they're doing, but they did it anyway because they're just so accustomed to it. I would love to say that, you know, we're electing progressive bench officers, but I have not seen it myself. I think they're responding to the law, and they may be starting to follow the law, but it's a long time coming, and they have not done nearly enough. The spirit and the culture of criminal punishment in this city and county is just dated. And I would like to think that it's progressed, but I simply don't think so. What I'm hopeful about is that this moment right now we're having where the police are being sort of uncovered for the world to see. That even in the midst of a police brutality protest, you're seeing police brutality, right? That finally that means the jurors will start to see that just because an officer with a badge and a uniform is on the stand speaking does not mean he's speaking the truth. And I think that I'm hopeful about that. I have way more hope in the people than I do in the bench, unfortunately.
Yeah, I'm going to go to you now, Professor Smith, and just ask what your general thoughts are with respect to the Constitution and these particular kinds of issues.
Yeah, I mean, I think you've identified some of the places, certainly in Eighth Amendment jurisprudence, where Justice Kennedy and Justice Stevens, neither of whom are on the court anymore, but where they were leaders in terms of now not allowing the execution of people who were kids when they committed their crime. I like to say kids. I don't like to say children. I don't like to say juvenile. And I like to use the same word that I use for every other young person. And I think that's part of it too. It's like, it's unlearning. I think all of us have to do this, and it's hard, but we have to try to unlearn these antiseptic terms that have been given to us to mask really modern horrors. But in terms of that, right, this is a cultural thing. The law does have limits. So some of this is gonna happen through art. Some of this is gonna happen by virtue of volunteering. I certainly, my own experiences and the way that I write. I mean, you go back to the beginning of my writing, and I was writing about James Madison and so forth. And what did James Madison and what did Alexander Hamilton think about such and such? And that's fine. I mean, I'm not disclaiming any of that, but I was with Alec Karakatsanis, who is now the head of Civil Rights Corps, and we were in St. Louis County, and we were interviewing people, and I was just looking at the system, and I'm not as close to it because I'm not a public defender, and this is not, like, there's so many areas of the law that depend on some degree of a functioning state and local system, and in front of me I was seeing something that simply wasn't that. And the way that people were describing how they were being treated, I looked at Alec and I said, Alec, this could only happen if people aren't viewing them as human, and they're not viewing them as human because they're Black and poor. I'm embarrassed to say that I said that because some people have known this longer than I learned it, when I learned it 6 years ago. But then once you see it, you can't unsee it. And so we need more people to see it, and we have to think about how can we get more people from a broader range of backgrounds to see it up close. And some of that is in our language, and some of that is in our art, and some of that is in the stories we tell, and some of that is just kind of more broadly the roles that we choose in terms of who we choose to be trustees for, moral trustees for. In my own writing, I've recently kind of made a shift, and I've started writing about the dead, which may seem like an unusual place to go, but I'm developing a concept that I'm calling spiritual reparations, where the question is, once people have they're dead, but they've experienced mass horrors, how do we deal with that? How do we still think of them as legally and morally cognizable beings to whom we owe something? And thinking about ways that law can do that, and that is for me, it puts me in a space where I'm able to talk more in direct ways about humanity and about how to get people to see how we got here, right? With the hope that if more people have a better and deeper appreciation of how we got here, and we generate law that kind of forces the telling of that story more frequently, then that too might elevate our understanding of humanity for people who are experiencing modern horrors.
Great, and that is why one of the reasons I use the N word in my title. I don't think there's any word in the English language that, again, more otherizes its referent than the N word, more, tries to more sharply distinguish and distance itself from the referent than that word. And that's the only explanation I have for how we can allow the treatment that we do allow of not only the prison population, but Black populations generally. I'm looking at Skid Row down here, like I said, 74.5% Black. And one of the, some of the research, and then I'm gonna go to questions from the audience. Some of the research I've done for this book has me going into, again, the cognitive unconscious. And when I first started writing about this back in the early 90s, I had to do all kinds of social cognition stuff because, you had to kind of indirectly find direction out, use these information processing approaches to human cognition to figure out what was going on. Now they have fMRIs with brain imaging studies. So we can say, here's your brain on race, right? And here's the picture. And what's coming out of these studies that I talk about in the book, that's really kind of the most depressing stuff I've looked at, and I've looked at a lot of stuff for a long time, is this phenomenon called in-group empathy bias. if you are, say, a white person, look at another white person drink a glass of water, you simulate what you see in your own brain. Your mirror neurons start to fire, and you simulate in your own mind, tipping the cup to your lip and setting it back down. These are the basic building blocks of sympathy and empathy, these mirror neurons. What they found is when a white person watching a white person drink a cup of water, that happens. When a white person watching a black person drink a cup of water, the mirror neurons don't fire. Period. I wish it was it, but I can't make it any plainer. The basic building blocks of sympathy and empathy aren't there, and it's all unconscious. And it explains so much to me. It explains Katrina. It explains the Ninth Ward. Day one, black people stand on the roof, water up to the neck, no help. Day 2, day 3, day 4, here comes Sean Penn handing out fresh water, still no FEMA, because they just got red tape. We just couldn't get our act together. When those planes ran into those buildings in New York, there was a panic of empathy for those victims, and we just got it done. Nobody want to hear about any red tape. Those lives mattered. Those black lives didn't matter. And now I see it's on an unconscious level. The lack of care, sufficient care and concern, empathy, that indifference, the dominant kind of racism today, I think, is that rooted in indifference, not intentional hatred. Right. And that's what's the most depressing thing that I came away with. I tried to come back up, but I just see, you look at Skid Row, like I said, down here, 75% black in LA. That's the Ninth Ward. Those are black folks standing up with the water up to here. But now forget 4 days going by, 4 years, 20 years, and we just leave them there. Right, with whole families, little kids, everybody, because those black lives don't matter at a neural level, at a basic level for many Americans. But let's go to the questions now. I think we're going to have, is it Olivia Hudnut that's going to help us out with the questions? Thank you.
Yes, thank you, Jody. And thank you, everyone, for your great questions. We'll be asking the panelists and also Professor Armour these questions now. Okay, so our first question comes from Ms. Joni Halpern. She said, I've been confronted, as my clients are, by judges who constantly threaten that if you exercise your right to trial and lose, he or she will punish the client even more. Even if I'm unafraid, my client is. What should I do in those cases?
Let's start with you, public defender Blacknell.
I think if a judge openly states that they will punish your client for going to trial, then you should file a peremptory challenge to dismiss the judge. They're showing an obvious prejudice, and I think you shouldn't operate in their courtroom. As far as your clients, it's interesting because I battle and I debate with public defenders all the time about this issue, about advising clients what they should do. Now, there are some folks who are afraid of being paternalistic and telling predominantly Black and brown folks how they need to behave and how they need to decide, and they want to empower the client to make their own decision, and certainly that is true. However, you're the one with the education. You're the one with the experience. You're the one that's done this before. Most of my clients have never been in a jury trial. I have a responsibility to explain the process to my clients, to explain the risks to my clients, to explain the avenues of success, and then to encourage them. You don't push anyone in any direction. But my problem with this analysis is that my clients decided that they don't want a trial is that a lot of these folks are eager to push a client to plead, but don't want to push a client to fight. So just be consistent in your methodology, right? If you're a person that wants to empower the client all the time. Because many clients will tell you they've been pushed to go to plea bargain, that they wanted to articulate, to assert their rights to trial. And the lawyer has told them to do that. So if you do have a fearful client, it's your job to encourage them with what you know, without making any guarantees, right? But if you go to a doctor and he diagnoses you with cancer, he's not gonna say, well, maybe you can take chemo or maybe you can't. It's up to you. The appointment's on Monday for you to meet with an oncologist, right? That's what he's gonna say. And you can certainly not make it. You can say no, but he's gonna tell you what you should do. And don't our clients, don't they deserve the same sort of professionalism and advice of our experience, our education? Of course they do. So I think that you do advise them, you do empower them, but you also recommend.
Great.
Thank you so much for that response. And now we have a question for Professor Smith. What is your opinion on the likelihood that we could ever begin to depart as a society from the notion that punishment must always be in tiny boxes where people are taught abject submission to authority instead of ways to strengthen their ability to interact successfully in society?
Well, I think part of it is talking about it in exactly that way, right? You know, even when someone is in jail for 2 days, that could mean 2 days that that if they work for a contractor or they work and paint houses, that they're not getting paid. 2 days that there's significant childcare issues, and where their child is asking, "Where's mommy?" or "Where's daddy?" And by virtue of that lost income, it could mean a major life shift, in which someone would have been able to make rent, but now they're not. And now they're living with their cousin, their aunt, and just generally trying to make things work. So I think just recognizing what a cage is and the gravity of it, even what we may sometimes almost think about culturally as de minimis, is, I think, really, really important. Now, in terms of the how beyond our language, I wish I knew more. I mean, every time I see jail and prison represented on television, I was watching a show last night on Stars. I'll just leave it at that. I won't say what show, that had a jail scene, and every time it happens, I there's just part of me that just hopes. I'm like, people see this as more than entertainment, and you're in LA, you're in the center, you're in my opinion, one of the most powerful cities in the world, because of the influence that Los Angeles has on our culture and what we see, and I like, so when I see images like that, I think that does more than any law review article I can write, or any, like, just because it's exposing it. There's also, in the show Atlanta, there's a scene in a jail that is just, that really manifests the inhumanity of it. And I think talking about it in real ways, one doesn't even have to exaggerate, just describing what it is, and describing what it is in the what we think of as like the short instances, I think can help us better appreciate when we hear things like 90 years. Like, we know 90 years is a lot. We know 10 years is a lot. But if we think about 2 days as what it really is, right? Then we start to think about 10 years in a dramatically different way. So I think we shouldn't even desensitize ourselves to these short spurts of fundamentally taking away people's liberty.
Thank you, Professor Smith, for that response. And it actually kind of harkens to a quote by Joseph Stalin: "The death of one man is a tragedy, the death of a million is a statistic." And if you look at it day to day, the suffering, it's easier for people to recognize what we're subjecting people to when we put them in prison or jail for just 1 day, instead of just saying 90 years and people kind of tune out. Yeah. All right, so our next question.
On that, I mean, I think that's part of, the story I just told me, it wasn't entirely hypothetical. It was a man I met, and we were at his grandmama's house, because that's where they were living at that point when we met him. And his 3-year-old son came home and went and hugged him, "Hey, Daddy," and hugged him really tight. And it was the scene of, like, that moment not being able to have happened when he was in jail. Like, and I don't know all the ways that we can have people see that and feel that in their hearts, and in their minds when they hear words when they hear things like jail or they hear criminal system. But I do think that can help us.
Yeah. All right. Okay. So next question, for Ms. Blacknell. What is your opinion as to whether it will be possible to address what seems to be the stranglehold on public opinion that correctional officers, unions, and private prison contractors have?
I think that people need to start, I did a talk once at Pepperdine where a young woman talked about all the legislation that recently passed, and she expressed her fears as a mother that these people would be released from prison, they would come and they would attack her children and molest her children and murder her in her sleep. And I reminded her was that the boogeyman almost never comes, right? This fear mongering that happens by police unions and correctional officers unions and DA unions about the boogeyman in the bushes, it simply never happens. And I reminded her, you should be more careful about who you leave your children with in your family. The boogeyman that you're thinking about, typically a black boogeyman, a large black, dark-skinned boogeyman, never comes. It's your child's soccer coach, it's your husband, it's your father, it's your brother. Those are the people who typically, from my 18 years of experience, are the perpetrators of violence against children, right? And so the women who are afraid that someone will break in their home and rape them and murder them in the night, the man you married is more likely to kill you than a strange man, right? And so I think we need to be honest about this stuff. This is not, the reason why you know Ted Bundy's name is because of his rarity, right? It is because he's an outlier. Most of the people who are in prison are not there because you are at risk in some way. They are there because the laws have empowered the people in power too long, because this is incestuous group of unions from the police officers union who catch the bodies, and then they give them to the DA who prosecutes the bodies, who gives them then to the correctional officers who cages the bodies, and they are in this incestuous relationship. So you should ask yourself, when you are electing your local officials, how much money have they been given? Are they bought and paid for? That is the question. There's a movement recently on the state bar to prevent DAs from accepting money from super PACs from law enforcement. That is something that is a reasonable request. We should not have our local prosecutors tainted by campaign contributions. And so I think that we need to, number one, educate ourselves on the actual statistics. We are safer now than we've been in 40 years. Okay? And so the idea that rampant violence will descend upon American cities if we release people is absurd. And we saw it in Los Angeles during the beginning of COVID. We had 17,000 people released from jail. We had 17,000 people in jail before COVID. COVID hit, we negotiated and litigated our way into making it 12,000, which is still tremendous. But guess what? No crime went up. You had 5,000 human beings released from custody in a very short span in one single county, and somehow they weren't raping and pillaging the town. It tells you that our reliance is too heavy upon police and law enforcement and prosecutors in prisons. And so I think if we're just sober-minded about things, and I'm a mother, I have 3 beautiful children who I would guard with my life. I'm not pro-crime, right? I'm just more rational because I've seen it myself. And I see what people are in prison for. I see what they go to jail for. There are people who are in prison for a life sentence right now that I would trust to babysit my children. But because we've empowered them with the legislature, have empowered them with these tools, which are the laws and the sentencing structures, they just run rampant. We did take away their tools, right? One in particular, the gang allegation. There's no one more demonized than black and brown men accused of being in gangs in Los Angeles. And they've given them license to treat them like a separate class of person. So if you're carjacked on the west side by someone addicted to meth, and the person gets up to 9 years for a carjacking in California. If you are a black or brown boy with a tattoo on your neck from a local street gang and you carjack someone, you get life in prison. Come on, that's racist on its face. So we can't be afraid of gang members, right? We can't let them trigger us into overly, killing an ant with a sledgehammer. And I think it takes bravery, it takes education, and it takes politicians with some fortitude to not be afraid to author bills to repeal the gang allegation and not be afraid of political pressure, because the people who run on fear mongering, they know what words to use. They find the most bizarrely despicable, horrific crime, and they describe it in great detail to trigger us. We have to stop falling for it.
just to follow up on that just a little bit, here in California, to demonstrate the power of the police, union, and law enforcement interests when it comes to their ability to contribute to campaigns and to influence outcomes through their contributions. They have already given over $2 million to Jackie Lacey, for example, for the DA's race here. But more importantly, for present purposes, those marches that were out in the street, because the DA's election is in November, just as important, but is ahead, is what just happened. You just had over 6 straight weeks of people in the street, and the legislators stepping up in the bluest state in the Union, California, the all-blue legislature, Democratic governor, Democrat, everywhere you look, you can't see anything but blue, blue, blue. And they came up with a suite of modest reforms, criminal justice reforms, modest ones. And all of them went down as soon as the people weren't out in the street anymore. They let them die. And then we turn around and we tell the protesters, just vote, just vote, just vote. I'm sorry to trigger anyone, my ass, right? When you see that kind of result from your vote in the bluest state, on the very issues you were marching about.
I mean, I will say one advantage that y'all have, and I've written about the initiative process in negative ways in terms of when it restricts liberty, but there's so much power in it in terms of the expansion of liberty. The fact that y'all are in a position to directly, in a way that, I mean, 27 states have an initiative process, but y'all really have one where, like, it's it's basically like a constitutional amendment that even the legislature can't touch. And to the extent that your representatives are failing you, I mean, this came to my mind when Colin Kaepernick said that he was sitting out a vote. And part of what frustrated me about that, I was like, but you're in California. Like, you're not just voting for the blue or red person to be in the state legislature, which is important in of itself. However, I get it. But you are a lawmaker, all of you, you're lawmakers. And so, and you've used that to great effect before.
Can I also say that despite LA's liberal reputation, we do have the largest jail system on earth. We do have, if you ranked Los Angeles among the death penalty in the country against states, we're number 4. Like we're rivaling Texas and Florida.
That's fair. I live in San Francisco, I forget.
I mean, LA County is literally in the conversation with Florida and Texas on the death penalty. The largest death penalty on earth is right here in California, in San Quentin. There's something to be said about Los Angeles and what it is and what it's not, because it's not living up to its liberal reputation in terms of justice reform.
So we want to be respectful of everyone's time, but this has been so engaging, and we were just wondering if each of you could share, maybe for 30 seconds, a takeaway for all our attendees on ways that maybe if the attendees are lawyers or people in the community, how we can challenge systemic racism.
All right, I guess we can start with Professor Smith and go to Public Defender Blacknell.
I'm not sure the answer is an entirely a legal one. The law is the consequence of our culture and how we see each other. And sometimes it's going to be at the vanguard, but not frequently. More often, we shape it. And so I think, this is going to be a vague answer because different people's roles will be different. Words that I use to guide me are love, imagination, and memory. That is deepening our love and our commitment to really, truly see each other and empathize and look for the gaps in our empathy and work to deepen it. Look at our memory in a deep way. Look at the inequality that's built into our memory that's helped to get us where we are and kind of undermines our ability to fully see each other. And in there also lies imagination. We're looking more deeply to the past that can kind of open up avenues that may not be directly in front of us. And we have to try our best to be bold enough to have bigger and wider imaginations. And so I know those are all vague, and they're going to bring up different things for different people in terms of love, in terms of imagination, in terms of memory. But I know that these aren't things that are usually said in a law talk by a law professor. But I do, those are my encouraging words.
For me, I think I'm not hopeless about the legislative process and about the voting process. I do think even in California this year, there are measures on the ballot about reinstating affirmative action, restoring the right to vote to people on parole. And there are also laws that they're trying to pass, law enforcement trying to pass to roll back some of the progress we've made with Prop 20. And it's obviously what's been called by the New York Times the second most important race in the nation is our DA in Los Angeles. So that's there. Always vote, donate, volunteer for campaigns. The second piece is educating yourselves on what's on the ballot in your local town, in your city, in your county, in your state, and don't follow the sound bite of the commercials or the Facebook ads or the 20-minute blurbs. Actually dig in there. If you're a law student, if you're a lawyer, you're educated. It's part of our responsibility as educated people to educate ourselves on what is important and to also educate our friends and family. And the third thing is about culture. Right? For years there were jokes about don't drop the soap when you're in prison, as if prison rape was some way a part of the accepted culture of prison. Take away that language, right, from people. Don't sit silently when people talk about criminals and crooks and thugs and gangsters, and don't allow them to use that dehumanizing language. It perpetuates it in the community, in our spirits, in our souls. The people who are in custody are someone's father and brother and son, people who love them and miss them and wish them to be home. And some of them have been sent away for the entirety of their childhood, their children's childhood, right? And they should be looked at in a way that's toward redemption, not towards damnation. And I think if we just share that sort of principle with everyone we meet or in these conversations, I think that will go a long way.
Our prevailing moral framework for over 40 years now has been retribution, retaliation, and revenge. I'm arguing in nigger theory, and I think we have to achieve more generally a shift in our moral compass, a fundamental overhaul in our moral framework from that to redemption, reconciliation, restoration, and rehabilitation. And that requires a deep, kind of taming of our retributive urge, which is, leading to a lot of, within the Black community, oftentimes it rears its head. And now, concretely, one of the things I found most effective at moving people's moral compasses in that way is art. When I had over in Bovard Auditorium, when we had 1,200 students there, the call to the question for my play for the evening was, should we pour liquor for Tukey? Should we express ritualistic solidarity with a first-degree murderer who co-founded the Crips? Right? Not talking about low-level nonviolent drug offenders. These are the people we got to talk about and change our moral compass with respect to if we want to make deep cuts in mass incarceration. And I knew that just lawyerly arguments and propositional content wasn't going to change the hearts and minds of the people sitting in the audience as jurors. As I was making this argument for the damned, I knew that I had to have art come in. And so I had exhibit A, B, C through G, Lula Barch and the dance company doing a modern dance. So Tupac Shakur's Brenda's Got a Baby, about a 12-year-old girl who is raped and has a baby. And the last couplet is her community turns its back on her. The last couplet is prostitute found slain and Brenda's her name. She had a baby. We asked, what if that baby that came out was Stanley Tukey Williams? Now he goes into the foster system, and you know what kind of hell goes on there, the locking in trunks for 6 hours for discipline, the cigarette burns, the molestation. And so we have just artistic performance after artistic performance culminating in Ice Cube and some other folks, right? And by the end of that night, you had 1,100 students standing up with their lighters in the air for Stanley Tukey Williams, because that's the power of art. Art can transform, right? It can change hearts and minds, and the voters' hearts and minds are who we're going to have to change if we're going to, move new DAs in and new lawmakers in.
All right, so we wanted to our panelists and moderator, Professor Armour, and remind everyone that we have an upcoming event. This is actually a series on racial justice. So we'll have our next event in October, week of October 12th. So keep your eyes out for that announcement. It'll be on voting. And we also I also wanted to plug Professor Armour's book, his posters behind him, N * DGA Theory. It's on Amazon, and also the Los Angeles Review of Books is offering signed copies. And to anyone that's interested, please check it out. It's a great book. And I also wanted to note that the Q&A will be answered. Any questions we didn't get to during the discussion will be answered via email, and a recording of this event will be sent to all of your emails as well. So thank you all so much for joining on behalf of the American Constitution Society chapter of Los Angeles. Yes, and thank you so much, and we look forward to our next event and seeing many of you there as well. Thank you.
Thank you for having me.
Yeah, thank you so much.
Thank you.